We're all down to shirt sleeves because it's so hot. Thank you very much for joining in on the latest of the Gray's Inn webinar series. We're focusing tonight on virtual advocacy and at an appellate level. And I have with me, and who will take part in speaking to you, Lady Justice Rose, Master Rose, and Richard Atkins, Master Atkins, both of whom have separate roles in this and separate experiences to tell you about. We're going to divide the session into several phases or sections. Firstly, I'm going to briefly address the documents which have been sent out to those of you who joined through the email link, all of which bear on the topic in hand. Then I'm going to do a little about criminal appeals and advocacy and running such trials or hearings. And then Richard Atkins is going to take over and talk about advocacy, virtual advocacy in crime in particular, but perhaps more generally. After him, Lady Justice Rose is going to talk about civil litigation and civil appeals conducted virtually. Then I shall do a little bit of a wrap up on my views on civil, and then we will take questions and answers, give you answers and take questions. So we hope to leave a decent amount of time for feedback from you and comment from you and questions from you. You will find at the bottom of your screen, if you move your mouse, a little Q&A icon. And if you do have questions along the way, please can you draft them shortly into that, and we'll try and keep track of them and field them at the end. But that's the easiest way to do that. So let us begin with the documents you've got. I have deliberately given you a short list of the relevant papers that may help anyone who's got to be an advocate or learn about advocacy in our modern remote conditions. Those of you who have the documents printed or can have them in your screen, the first is the information on Queen's Bench Division court users to do with coronavirus. Then there's a protocol about remote hearings. There is a practice direction which permits remote hearings and specifies the circumstances under which they are to be thought of as public hearings and how that should be arranged. There is general guidance on preparing PDF bundles for use in remote hearings. There is a protocol on reserved judgments in criminal appeals, which the judges will follow, but which are relevant for advocates and lawyers to know. There is then an extremely useful document published by the Inns of Court College of Advocacy, which is entitled Principles for Remote Advocacy. I commend that very highly to you. I'm not, of course, going to try and repeat the contents, but it is an extremely good and valuable help as to how an advocate should prepare for and approach advocacy in all appellate levels and indeed in all hearings. And at the end of that document, there is a first-rate list of links to other material which bears on how such trials and appeals can be approached. The final document is a lecture which I had the pleasure of giving a couple of years ago. Some of it's intended to amuse, but isn't all that serious. And the latter section of the lecture is directly relevant to what we're dealing with tonight. Because one of the critical themes that will emerge from all of our treatment of what needs to be done to accommodate virtual court hearings rather than face-to-face is that we really do need concentrated, thought-through, short, clear submissions because of the pressures and difficulties that sit alongside running a hearing of this kind. So that gives you a basis in material to take away. And those of you who are skilled enough to look at any of that while we proceed. Let me turn then to criminal appeals. The first thing to understand is the pressure and volume of work that is now having to be dealt with through virtual hearings. It is normally the case in the Court of Appeal Criminal Division that 5 or 6 cases will be listed before a given court for one day's sitting. We are now listing 7, 8, and occasionally 9 cases to be heard in a day. And that is really hard going. It's particularly hard going because the process of advocates and prisons being connected between one case and the next is necessarily quite slow. One cannot have all of the participants in the court's list joined up at once because all the cases are different, the advocates are in different places, and because very often the applicant or appellant will be in custody and therefore the prison needs to come in. It may not surprise listeners to realize that prisons are often fairly slow about coming in at the right time. There have to be pre-arranged time slots, and it is the custom and necessary in criminal appeals that the judges, when sitting, will listen to the submissions made in a given case and then will wish to discuss them before reaching a final conclusion. And that involves, in the normal way, the 3 judges simply leaving the courtroom and standing outside and conferring, and can come back in a moment or two if that's all the time that is needed. But when one is operating virtually, even once everybody is connected and all the arguments have been gone through, the judges then need to leave the virtual courtroom and reconnect virtually by other means. Since the law requires that one of the judges is physically present in the courtroom in criminal appeals as opposed to civil, that means that one judge at least will need to disconnect a laptop or leave a laptop and reconnect by other means outside the courtroom, have the final discussion, then go back in, then reconnect, and only at that point can the decision of the court be announced. And so there is a degree of necessary, glitchy, troublesome, time-consuming breaks in the course of a criminal list. All of that lays huge emphasis on advocates being crisp, being very well prepared, and coming to say only what they really, really do need to say. And advocates and the public should understand that before we come into court on any appeal, we've read all the documents, we have looked at the written submissions in detail, we have formed usually a provisional view subject to what is said orally, and there's really no need to start by telling us what the case is all about and retailing the story. Another aspect for the judiciary of criminal appeals is that very often there are victims or members of victims' families, as well as families of the applicant or appellant present in court. That can give rise to real case management problems in any event, even when we're present. But when one is operating remotely, it's not possible to see the people in the body of the court with any clarity. And one has to be sensitive always to the impact of hearing the details, which may be the details of a death or the details of a terrible crime, upon the family who are, to us now, essentially invisible. And judges will always take care to try and accommodate that and respond to the fact that victims can be present or those closely affected by what is happening will be present. So that is another layer of problematic management for the court. Finally, when one concludes an appeal in crime, 95% of the time, the judgment will be delivered then and there, usually quite shortly. We are reserving more judgments than normally because of the time pressures, which adds to the work outside the courtroom. But we still do our best to deliver immediate judgments where that's at all possible. You'll understand why, because so much depends on the outcome of a criminal appeal. It may be that someone, if they succeed, will be released the same day, and they do not want us to take a week or two, or even a day or two, to reserve a judgment unless that is really needed. I hope that gives you some overview from the judicial point of view of what this, it's always hard work, but even harder work under the current circumstances can be. So with that start on criminal appeals, I'm going to ask Richard now to come in and explain how horrible we are to advocates like him when he has to appear in front of us. So I hand over to Master Atkins.
Thank you, Steve. Well, I appeared in front of Lord Justice Irwin just over a week ago, my only virtual appearance in the Court of Appeal, and any of you who follow me on Twitter will know that I said he's as charming in court as he is out of court, and it was an absolute delight. I'll have a plug at Atkins QC. You can increase my followers. People have said to me, will virtual advocacy diminish the powers of the advocate? I don't think it will. Advocates have had to adapt over many years to all sorts of changes, and this is just another challenge that we face. In my view, the good advocate will always change and adapt and find new ways to shine. And as you're all, I hope, members of Gray's Inn, it's a given that you're going to be good advocates, I'm sure. A few headings, really. The first is, don't be downhearted. Embrace the challenge, work out what makes you a good advocate. I tell everybody, baby barristers, even more senior barristers, if you see somebody do something you think is good, steal it and use it. If you see someone do something that's bad, make sure you never do it again. And the same applies here. I'm not going to claim I've got all the answers. I may not have very many of the answers, but I'll give you a few tips. The first thing to do is to check it all works. Have a trial run through, make sure your equipment is working, make sure you know how to work it. Have a practice run through. If you can dial into the court and check everything works, do so. If not, try and get a mate to help you run through a few things, and check your internet connection is working. Check if you've got to put 50p in the meter, you've put 50p in the meter, whatever it is. Make sure if you're going to be working not at home, you've taken your cable with you so you don't suddenly find the whole thing shuts down. Make life as easy for yourself as you possibly can. If you're working at home, probably best to shut the door, put a sign on outside saying, I'm in the Court of Appeal. I don't suggest necessarily you tie up the children, but you need to make sure that people aren't wandering in. If you're in a small place, you don't need your mate, your partner, whoever, to be wandering past behind you, having just come out of the shower. A couple of things I always check. Your mobile phone, switch off the Wi-Fi so it's not sucking the broadband out. Don't put it anywhere near your microphone. It makes a horrible racket. Switch your iPad off as well. If your kit is working, you've overcome the first problem. Next thing, check the view. What's behind you? I've been training some advocates, Gray's Inn students, circuit people, and you'd be amazed at what you can see over people's shoulders. It might be the pile of washing that they've forgotten to move. It might be the clothing they've left out for the next day. Lord Justice Fulford has suggested we have a sort of bland background. I've actually got a screen from an old projector that I can put behind my chair. The only problem is if I push back, it falls down. Some of you who are more technologically proficient will be able to use green screens, but as you can see, Lord Justice Irwin uses his study, and you can try and identify what he's been reading of late. I don't think there's too much of a problem. I try and ensure that I don't have anything too garish in the background. And another thing to be aware of, apparently on Skype, What you see when you're looking at yourself on the picture is not necessarily what somebody else sees. I'm told that they may have a wider view. So you may think you've hidden things, but they may be able to see far more. So check the view and make sure that everything's working there. Check your own setup. Make sure that everything is ergonomically set up for you. I use two screens, so I'm looking at my laptop screen here with the camera on the top, and I have a second screen immediately above. The notes I'm reading from, I have just above the camera. So I'm trying, I hope, to look into the camera rather than down here or over there, which I did with one student who for some reason had all her stuff over here. It's distracting. You need the judge to feel as though you are addressing them rather than you are distracted. Make sure you're comfortable. If you're in a position where you don't have a particularly good desk and you're balancing things, everything's going to fall over at the exact moment that you hear all rise and Lady Justice Rose sits down for your submissions. It's not a good look as you go scrabbling around. Also, work out where your controls are. I sit as a mental health tribunal judge, and I've been conducting telephone hearings. You'd be amazed at the number of people who cannot mute their line or cannot unmute their line. So work out where everything is, make sure you can deal with it. And the other thing is, look at yourself and make sure you're okay. That is not a good look when you're trying to get something across to your Lady or Lord Justice of Appeal. They don't need to be headbutted. They want to listen, they want to get the best out of you. Try and make it as good for them as you can. You've got everything sorted, you're getting ready for the hearing. A skeleton argument is your biggest weapon, I think. Get your best points in succinctly. They've got lots to do, but make sure you've done the groundwork. Get it in advance and make sure you know it. But don't then just read it out when you appear in front of them. Lord Justice Irwin said to my opponent the other day, take it, we've read everything, you don't need to go into everything. And of course, what did he do? He was quite junior, he was nervous, he didn't listen, bang, he went straight in with a whole load of stuff that was utterly unnecessary. It didn't matter, Lord Justice Irwin, as you would expect, was absolutely charming. Rumour has it, nobody on this screen, of course, but rumour has it, perhaps not everybody would be quite so charming. But if a judge tells you, I've read it, then, you know, take the hint and go to your best points. If you're responding, as I was in the appeal that I appeared in, you've put the groundwork in, you've put your skeleton in, a handful of points is all you need. Just get ready to hit when they say, and Mr. Atkins, anything? My lord, 3 points. They don't want hours. They haven't got time, and there's always that awful moment that just as you get into your best point, the screen is going to go down. So make sure that you listen, you look, and as I say, look at the camera. I've seen a picture of somebody who apparently, who has cut out a little face of a judge, and they've put it slap bang over their camera. So they actually have a little judge they can address to remind them to look at the camera. It's a very good tip. I think it works well. I think probably that's about it. Make sure, sorry, you cut out external noise. That's the one thing I disagree with the ICA, the advocacy toolkit about remote advocacy. They say there you shouldn't be wearing a headset. I don't have any problem with it whatsoever. In fact, I think one of the wingers, one of the judges sitting with Lord Justice Irwin, was wearing a headpiece. If it means that it cuts out external noise and everybody can hear you much better, the fact you look like a pilot, it matters not. It's a new world out there. So that's the one thing I would say, don't worry about. If you're in a team of people and you've got a junior or you're working with somebody else, have some way of communicating with them. So I have my phone, WhatsApp messages can come in, but obviously I don't want to be looking at lots of it. But I think that's about it. Normal rules of advocacy apply. Anyone doing criminal law should have done the vulnerable witness training. That really does come home for anything you're doing virtually. Look at it, strip it out, look at it again, strip it out again, bare bones, give them your best shot. Good luck. I've done one so far. I've won one. I'm doing another tomorrow in the VAT tribunal. Hopefully I've not put the kiss of death on that, but I hope you all enjoy your virtual advocacy. Thank you.
Well, thank you very much, Richard. Some response to that. First of all, nobody minds if you wear a headset. That's straightforward. We all know we're wrestling with this technology, and if that makes it easier for you to hear, but also makes it easier for us to hear you because the microphone is close to your mouth, you might want to just clear or tell the court clerk beforehand you'll be doing that, but nobody will mind that. The ICCA, the ICA advice, really everything Richard has said, apart from the headset, is there and much more. And I'm glad to see that he entirely agrees with, or what he says is entirely in line with that. It is a really first-rate set of advice set down there. And I would really commend to anybody at any level to read it, because it gets under the skin of this process. On skeleton arguments, something that always was right was that the skeletons should put up front the propositions that the advocate is trying to advance. And that is even more important, as Richard has said. The very worst kind of skeleton argument is the one where you get to page 17, and by then the author of the skeleton has worked out what it is he or she wants to say. And all the rest is their thought process as they get to the propositions that they're going to advance. We all have to go through those thought processes to boil the thing down. But for goodness sake, I don't want to watch your thinking. I don't want to sense the way you're going until you get there. I want to have your propositions at the beginning. Shortly put, 1, 2, 3, 4, 10 if you must, but preferably 3 or 4. And then tell me why you're right. But I want to know what you're arguing for first. And that is as good a piece of advice for ordinary advocacy, but it's very important for this, where we're under such time pressure and where communications may not be ideal. I was intrigued by Richard's point about realizing what can be seen behind you. I hope nobody has such vision that they'll pick out the novels that are behind me. Actually, they're not novels, so you won't be able to. But it's a generally good rule to realize as an advocate how much can be seen behind you by the judiciary, by the judges, and by the jury. And I learned it very early on as a recorder, because I was sitting in a Crown Court in a very tin pot, not very serious criminal trial. There was a solicitor's clerk. Into the witness box went the defendant. And in the course of about the first 20 minutes, he said the wrong thing, the crucially wrong thing. And his solicitor went, and we could all see the shrug. We could practically hear the click of his tongue. We could all have gone home, because that little gesture by the solicitor, who hadn't thought that he was being watched by everybody, gave the whole game away. We all knew that that was not what his client was supposed to say. It was the critical fulcrum of the case. We could have saved 3 days in court by just them giving up at that point. Always be conscious of what's going on behind you. Always be conscious of that we can hear from the bench, even under these circumstances, far more than you think we can hear. We're not all deaf, though sometimes you treat us as if we are. And particularly with this technology, whether it is Skype or Zoom, if the judges retire by turning off their microphones and turning off the cameras, that doesn't stop us hearing you. So I have twice now had to go back in and say to counsel, do you realize we can still hear you? In one instance, the junior was telling the leader that she thought he was doing a bit better now, which wasn't the message she would have wished to convey to the bench.
It wasn't my fault.
It wasn't your junior. It wasn't, but it was a serious case. It was a difficult argument. And so we left, and I had to say, look, we can hear you, because I had to stop her before it went on into something even worse. Anyway, so bear in mind that we will be listening and watching as closely as we can, and that includes you. If you need to talk confidentially, make sure that you turn off your microphone, even if we've gone. Anyway, can I ask then to hand over to Master Rose to talk about civil appeals and advocacy remotely?
Yes, thank you. And I absolutely endorse all that very practical and useful guidance. And that certainly chimes with my experience now, having done quite a lot of remote hearings in the Court of Appeal Civil Division. I want to change the direction a little bit and look to the future, and what the Chancellor referred to recently in a speech to the Chancery Bar Association as what's the new normal going to be? How are we going to carry on with remote hearings once the pandemic is finally in the past? And I also want to focus on what your task is in conjunction with the judiciary as advocates in the more abstract aspects of a hearing, rather than just making your oral submissions, because I think that there's a lot that we need to think about as how remote hearings compare with in-court hearings, as far as what I like to think of as the cathartic process of the court hearing, which I think we all experience, even if it's quite difficult to describe. One of the points that's been made is that it's difficult to judge from our experience in lockdown how it would work having more remote hearings once everything is more back to normal, in terms particularly of staffing levels in the court. I think a lot of the glitches that have occurred, bundles going astray, reduction in the amount of business done, is the result not only of everybody getting to grips with the technology, but also with there being a much reduced staffing level within the courts. We all remember those extraordinary weeks in the middle of March, where every day things seem to be taking step changes and new guidance coming out, with the leadership judges really working around the clock for things to devise and issue new practice directions and rules. Now, the Court of Appeal Civil Division, our cases are, one might think, the most suited to remote hearings, because most hearings are a day, 2 days. There are no witnesses. We only ever hear oral submissions from advocates. I mentioned bundles being a particular bugbear, and you do need to remember, whilst you're in lockdown, that the judges don't have their usual support network, and they're doing a lot of the bundle management themselves, whether it's electronic or whether it's hard copy bundles, and judges vary as to the level of comfort they have with dealing with the one or the other. And one of the things I've noticed can be frustrating is this avalanche as you get towards the hearing of documents coming in attached to emails, which appear to be identical copies of things that you've already had, things that are already in the hard copy bundles. Why am I being sent this? It doesn't say on it, is this different? How is it different? So one tip I would give you is if you are sending through a new document, explain whether it's a replacement, whether it's an additional one, and if it's a replacement, why you're replacing the one that the judge might already have marked up, either electronically or in hard copy. But I want to move on then to think about whether the remote hearing, and I'd in the Q&A session, I'd really value hearing from advocates, whether it reduces the effect of the process of judicial determination. When I joined the business and property courts, the thing that struck me, which I hadn't been expecting, was how much drama and emotion there is, even in what might, when you look at the judgment, seem to be a rather dry company law, equity law point. A lot of the work is, and in fact, the very first case I did as a High Court judge and the last case I did as a High Court judge, it's two alpha males. They used to be in business together for many years. they have a spectacular falling out, and they express their anger and their upset with each other through the litigation. And for them, the point of it is not the legal aspect of it, it's the being heard. And when I, now in the Court of Appeal, we get a lot of those sorts of cases. I don't know if there are any chancery people in the Zoom, but a lot of family disputes over close held companies, farms which have been promised to one child are then being, the parents are threatening to leave it in their wills to the sibling. And there's a lot of heat. And as a judge, I've always thought that one of my tasks is twofold, really. One is to provide a non-violent means by which people can bring these disputes to court and get them resolved rather than just slugging it out in a car park. And the other is to sort of rather psychobabbled speak, but I think it is important that the person who loses understands why they've lost, they've gone through the process, and they can then achieve closure and move on with their lives from this terrible, bitter dispute which has consumed them emotionally and financially, often for many years. So I certainly am thinking about the point that Master Treasurer made about the difference it makes that I can't see the parties and they know that I can't see them. And does that affect the extent to which they feel heard, acknowledged by the process of the judicial determination? Now, Master Treasurer and I recently sat we handed down a judgment in an appeal on a judicial review claim of 4 single mothers challenging an aspect of the implementation of the Universal Credit Scheme. And their witness statements contained a lot of very personal and painful detail about their struggles with managing on the money that they were getting. And we were on a Skype for Business call. I could see their little tiles with their names, but I couldn't see them. They could see me, but I couldn't see them, and I know they knew I couldn't see them. Now, as it happens, they won, so I'm sure they were very delighted, but I felt if they had lost, would the process, as far as they're concerned, have been diminished by the absence of that eye contact that you have across the courtroom as a judge with the lay client sitting behind the barristers and the solicitors. And I was talking the other day to Lord Justice Dingemans, who was sitting with the Master of the Rolls on the Chagos Islanders case. There were about 100 people on the Skype call, including a lot of islanders now living in Mauritius and in the Seychelles, and many others more watching on the live stream. So there's a big advantage of doing it remotely, because obviously not all of those people could have taken part in the hearing. But again, the impact on both the bench and on the islanders, the clients, of that absence of contact and the drama of the court process, I think does need to be thought about. And can advocates and judges do something that helps in some way to, if not replicate it, at least bring about the same effect? And the other point I want to make finally is about that there's particularly discussion about remote hearings and their suitability for interlocutory hearings and case management. And I agree that, yes, one might say, if you save all the rail fares and having to get everybody, travel time and getting everyone in the court. But having sat a lot in the applications court, I know that very often just getting everybody in court, especially if they have to hang around outside for an hour or so, they not only will actually resolve the application and present you with a consent order, but they might also actually settle the whole case. And another thing I think we need to look at for the future when we're thinking about carrying forward remote hearings after the end of the pandemic is, what do the advocates think about whether there is a reduction in the opportunity for settling a case if they're not all together in court at the same time with the barristers, the solicitors and the lay client all there, able to kind of hammer out a deal on the bench, or, you know, on a table or in a conference room, to resolve that. Because I think that it would be a shame to lose that ability to lock heads together by being rogue. It may be that actually the same thing does happen, and it's just the hearing coming up rather than everybody being present. That is the important thing. I don't know, but I think it would be useful when we're thinking about our experience going forward and what should be taken forward and what we should leave behind, to think about advocacy and your role as advocates in assisting the court and assisting in the achievement of the overriding objective in those more abstract ways, as well as in the very useful practical ways that we've also been discussing. Thank you. Yep.
Well, again, I echo a great deal of what Master Rose has said. The distancing effect of the remote process is a real one. And I think we need to think carefully about how to overcome that, to accommodate that. I'm not sure that it is possible to do it fundamentally. I think that there's a degree to which simply not seeing, hearing, seeing people in the round, looking at the absorbing the interactions within the courtroom is something that can never be replicated through remote means. But we need to do our best to do that. And you do surprisingly often, when you get to the end of a difficult case, civil or criminal, you do as a judge sense that there is a resolution from the parties or from the families or whoever might be involved. And of course we don't have that sense now because we don't see any of the reactions that come to the decision, even if the decision is announced then and there. In a funny sort of way, it's accentuated because it's not even the outcome that always leads to the sense of resolution. You can see that if someone is responding to the argument as it develops, that also means, well, at least what I feel has been expressed, and you can sense that it's been expressed. Sometimes it enables one to move an advocate on, because you can see that the point's been made and she doesn't need to say it again. So there are all sorts of ways in which the remote advocacy or the remote trial system presents things that I'm not sure can entirely be overcome, but we will all need to do our best to do that. Indeed, that theme touches on one of the questions that has been asked by one of our participants about the security of the process, because the case that Master Rose mentioned was one of those, and there are many, where one might have interventions by people who have an interest. You don't always know who they are, because all you see in this is a series of names, and some of them will be clear who they are, but you don't always know that. And I think that therefore actually dealing with potential disruption and security is more difficult in this context than it is face to face. I think the question came from, if I pronounce it right, Kalo Rashiga Seneviratne. How do we deal with security and hackers? I'm not sure that I know the answer. Skype for Business has the capacity for the controllers, in most instances the judges' clerks, to shut off a participant. So they can close a participant down if some sort of intervention or abuse happens. But someone who shouldn't be there, for example, who may be a witness coming later or coming tomorrow, who joins under a false name, I'm not sure that there's any way to crack that in the way that it could be dealt with in a criminal trial, because people will be aware of who's in the room, who's in the public gallery. So I think that that's a good question, but I'm not entirely sure that I know the answer. One way of completely secure communication is WhatsApp. And my own practice is, when I'm communicating with other judges in a case, in an appeal, I don't use Skype for Business because that isn't secure. But if you use WhatsApp, that's encrypted end to end, as lots of criminals have found useful as a function of it. But we do that. And you can communicate either by messaging or by audio call or by audio-visual call. Obviously, you don't do audio-visual while you're in the courtroom. But that is a very useful, and that is a secure means of communicating. I wanted to pick up on one more thing that Master Rose said, which is the challenge for the judiciary of document handling. That is dealt with in part in the ICCA guidelines. Very often, I think the directions say that there should be PDF documents delivered in civil appeals. And that's fine, but please make them tabbed so that you can click on the document and that you will go straight there. Do not put the control on that means you can't display the whole of the page except within the screen. I can't tell you technically what that control is, but I've had it in more than one case where on a laptop screen, in order to move down the page, well, you can't move down the page. So you have to somehow peer, looking like Richard Atkins' imitation of a killer a few minutes ago. You lean forward and peer into the screen because that's the only way you can see the text. And the alternative is if you press the down arrow, you find the page flips to the next page. It's completely infuriating. So tab each page in the PDF. Make sure that we can scroll down the documents on a laptop screen, and don't send it to us before you've done that. Edit, edit, edit what you're sending to us. It's even more important in virtual hearings than in paper hearings. It's been a disgrace for years that you get 4 lever arch files of documents, of which we look at 35 pages. It's even worse of this. And I think that there's a developing tendency to think, well, since we're not printing it, it doesn't matter. It really matters, so that we can have a proper bundle, only reading what we need to read and able to move within it effectively. Richard, I know that you need to leave us before too long. Is there anything you would like to come back in on, having heard what you have heard so far?
I think there were a couple of things I was going to say. One is beware or be aware, which we've touched on. It's when all you've got is pretty much the face. It's amazing how things can be given away. It was picking up on you saying about the solicitor making a comment. I've seen people in advocacy exercises, and I'm sure it'll happen in court, where people will suddenly go, and you can see they just don't have a clue. So remember your face, you have to have your poker face on. The other thing is beware or be aware. You don't necessarily know, picking up on what you said, Master Treasurer, who is listening in. Not just the fact that the judges may have retired but can still hear. You could have, depends on what the case is, the press can be listening in. You may have victims, relatives of victims, and it may be that you can see your mate on the screen, but lots of people can hear what you're talking about. So just be very careful. Less is very much more. And of course, there was a solicitor the other day who had to apologise because some comment was picked up. It hit the press about a fortnight ago that was broadcast. So I think those are the main things I would pick up on. And I see that we've had a question before I duck out. I'm sorry, I have to go to my Chambers AGM. Somebody asking, do we find these hearings intense? I think it depends on the person. I quite enjoyed the fact that I didn't have to get up at 6 o'clock in the morning, catch the train from Birmingham to London, wait around and then come back. I sort of sat down 15 minutes before the hearing, up I popped, 15 minutes, half an hour, and then out. Having said that, I've got a 2-day hearing starting tomorrow, going into Monday. I may well think very differently if I'm doing an entire day's worth of work. But I've quite enjoyed the virtual advocacy.
Well, thank you very much. I think to deal with the intensity point, I think it can be intense, but what I would say is that it's more tiring. It's more exhausting, because if you're attending to relatively small screens and they're changing and the technical capacities may differ. So yesterday's hearing, which I carried out from where I'm sitting, one of the silks clearly had a not very good microphone, and he was having to literally shout at his own laptop, and we were still having to strain to hear. And that can be a very tiring process. I think everyone's response has been the same. Whether it's more intense or not, we certainly find it more tiring and more demanding than sitting in court. I think because of the absence of clues and prompts from the way the room is working. You know, if you've been an advocate or a lawyer for however many years, then you're used to picking up clues that are non-verbal as well as the verbal things. And you lack that. So that's partly why it's tiring.
Yes, I agree with that. And I think it's also the kind of underlying anxiety about whether the technology is going to behave itself, I think, is also rather stressful. And it must be even more so. I mean, I've been doing, I've got a 6-day appeal, which is a rare thing, with sort of 20 volumes of documents, which I'm doing actually from my room in the RCJ rather than from my dining room. And we're using the Opus Magnum platform rather than a platform that we're more used to. And it has worked well. Other platforms are available, but it hasn't been trouble-free, and the kind of anxiety of delays for everybody, and it's not necessarily the platform fault, it can be the fault of all sorts of things. So I think that is a kind of an added underlying thing that makes it tiring.
Will you forgive me if I drop out? And I'll wish you all well, stay safe, and I look forward to seeing many of you virtually and hopefully in reality in due course. Thanks.
Thank you very much, Richard. Thank you. I wanted to come back to a couple more questions we've had. Karen Ray has asked about CVP. That's Cloud Video Platform, if I've got the acronym right, which is the vehicle by which criminal appeals are conducted. As I understand it, and I can't pretend to be highly technical, the point about CVP is that it is a platform through which any of the different technologies, Mac, WPs, Microsoft, or others, can operate. It's deliberately designed as a kind of common meeting place for all those technologies. And I think that that's the reason it was chosen. It's not as smooth in operation, is my experience, as some of the other specific platforms where everybody is sharing Zoom, Skype for Business, or whatever. But it may be necessary because, frankly, the technology for video link in prisons is primitive in some of the places, slow and primitive. And if that's to be accommodated alongside the other technologies that people have, and you never know, with 7-8 cases a day, you never know what people can use or what the conditions are. So I think that's why that is the enduring means of dealing with criminal appeals. It means, for example, that judges who are doing criminal appeals and civil appeals have to get used to operating completely different systems for those two categories of case, for what that's worth, and we get used to it.
Yes, I mean, in the civil appeals, they had one weekend in the middle of March when they had to decide, okay, we're all going to start working remotely, what platform are we going to use? And they opted for Skype for Business, which has pluses and minuses. And I've been using that and Zoom for meetings, and also, as I was saying, the Opus Magnum thing. I was a bit disappointed the judges didn't decide to use House Party, which I think would have been rather fun. But in fact, I find that they all do pretty much the same. I think Teams, which is supposed to have taken over from Skype for Business, was not very good in that it initially was very limited as to how many people you could see at the same time, which meant it was not very appropriate. There's a couple of questions coming in about what level of technical support is supplied for judges. Well, that was, I mean, it is amazing, really, considering that there's a great range of abilities and experience amongst the judiciary, if I can put it diplomatically like that. Some are great techie experts, and some are not really comfortable using it. But everyone has really stepped up, and the support that we got for working with Skype for Business in those first weeks was really marvelous, and I can only pay great credit to the IT people here in talking everybody through those first very difficult days of installing the stuff. There are some clerks who have been identified as having kind of IT skills who are very available, and really it has been tremendous, the support that we've received, and has involved people going far and beyond their kind of their day job, as it were, in order to make it all happen. And I hope that ultimately will be recognised in some way.
Absolutely endorse that. At High Court level and Court of Appeal level, I think it has been very different for the County Court and the Crown Court, simply because there isn't the concentration of resources or the availability of skills. We've got some other interesting questions, and I want to try and pick them up if I can. Firstly, picking up Tajwa Shalim, who is asking about the backlog of cases as a result of all this. And would one of the ways post-pandemic be for trials to manage cost, time and general admin through using remote technology? I think there will be more use of remote technology, particularly for interim hearings and preparatory hearings. I do not think that criminal trials will be conducted through remote technology, except to the extent that witnesses may be more, we may be readier to have individual witnesses brought in that way, particularly if they're not controversial witnesses. But just as it is, as we've been saying, it's more difficult for the judge to read the room, or not possible sometimes. So also I think it's definitely more difficult for a jury to read a video witness than to read a witness in person. So for someone who's giving evidence that's really critical, perhaps where their credibility is at stake, I don't think the technology provides a satisfactory answer. And it would be a trap driven by cost if we allowed ourselves to be pushed into compromising the quality of what we do simply because it's a bit cheaper or we've got used to using some of it. That's quite an interesting question. I then want to pick up on the next question. All representatives from Chris Mallet. Representative judge in a hearing suffer from the furnishing of overlarge bundles. Yes. Can anything really be done as a solicitor that fails to file the important document can find themselves in trouble? Well, what can be done is to decide what the bloody important documents are beforehand. That is your job. And we may be speaking mostly to barristers or aspirant barristers, but your job as a barrister is to tell the solicitor, get it together, prepare ahead. Of course, we all know that sometimes a messy bundle of documents arrives with you far too late, and you don't have time to sort out what is supposed to be produced. I've never forgotten when, quite a junior barrister, I had a deeply inefficient solicitor who never copied the documents. Every time she sent brief to me, the brief in the back sheet said, "Would counsel please advise and represent?" And inside were the original documents from her file, which was all very well until one day when the motorbike courier crashed on Fleet Street, and her original file was distributed by the traffic everywhere from Farringdon Circus to the end of the Strand. Placed me in a little bit of difficulty when I appeared 2 hours later without anything to use. So the real reason is preparation. The real answer is preparation. And solicitors' job is to do that properly. They will get in trouble, but they'll get in trouble with me if they haven't thought what they need to produce beforehand. Counsel are far too protective sometimes because they want to be instructed again. Now, I understand why, but that's the sort of thing that really should be made clear.
The thing that always astonishes me is the kind of, in a big trial, is the loads of the lever arch files of solicitors' correspondence, which is copied umpteen times. And I mean, if you go to 1 or 2 pages in that, it's extraordinary. And that seems to be just a complete waste of effort. It always astonishes me that professional lay clients aren't more aware of this and don't keep a greater rein on it. I always think if I ever had the misfortune to be involved in litigation, I would say to my solicitor, you are not to write more than a 5-line letter without my express say-so, because these endless 5-page, closely typed, contentious sounding letters just drive me nuts. As far as how we will go forward, I mean, I must say, I think that the days of us all going into court and handing down a judgment for a completely empty courtroom must be finished now. I can't see us ever going back to actual physical hand down of judgments. Now we've got out of the habit of that. And that seems to me that kind of post-judgment hearings, unless there's something really substantial, seems to me that that's an area where we could very usefully just remain online. Somebody's asked about hybrid hearings, and the Chagos Islanders case was, I mean, that was, and it's hybrid in a number of ways. In that case, the Master of the Rolls was in court, so there was the Skype for Business call with the participants on, including the 2 other judges sitting remotely. And then it was also live streamed, and the live stream had a camera on the Master of the Rolls and a camera on a computer screen on which the Skype for Business feed was coming up. So I can see the benefit of that. I quite agree with what Master Treasurer said about that you do need some kind of backup way of communicating with each other, both the judges amongst themselves and barristers getting instructions from solicitors and solicitors from lay clients. And it is useful to have a little WhatsApp group going or be sending each other texts. And that's also a good backup in case the feed goes down. You can text someone and say, you know, are you still there? So I can see that there is a kind of, once we're back after the pandemic, I'm sure there'll be lots of kind of more creative ways of having hearings which are a mixture of remote and court-based.
2 more questions have come up that I'd like to respond to. One is from David Emanuel. In your experience, what makes for the best oral advocacy in CrimDiv, CACD? I think that thinking and analysis make for the best advocacy anywhere. If you get an advocate who says, I've got 4 points, but the critical point is this one. So I'm going to start with that. And the proposition I have is XYZ. It doesn't matter whether it's virtual or live. That's your heart rises because you know someone has thought it through properly, simplified the proposition, identified the proposition, and has had the courage to stick by what really matters, rather than throw every point at it because that might work. And having that courage, following analysis, it's that combination which really impresses.
Yeah.
Do you want to come in?
Yes, I agree with that, and I think that I always sort of tell advocates that as an advocate, you cannot overestimate the extent to which every judge, from the moment they open the papers, is thinking about writing the judgment. That is our great obsession. It's the fact that once the hearing is finished, we have to produce a judgment. And that is what every moment of the judge's attention is directed at, or in the criminal context to do a summing up or sentencing remarks or whatever. And any advocate who can help with the structure of that is going to be on a winning streak, as opposed to, you know, headline the meeting of the 4th of November, he said this, we say that, you should find this. Well, yes, fine, but how does that fit in to the chain of reasoning by which I actually arrive at the answer as to who's going to win and who's going to lose? So I think that that's right, and I think that that's as much the case for virtual advocacy as, and I think with virtual advocacy, I think the key thing is knowing your way around the bundles and being able to present it in a way which doesn't overload the judge with, oh, now we're looking at this folder and that tab and whatever. I think you have to keep the documents, knowing which documents you're going to ask the court to look at, and which you're just going to say, you know, your ladyship, for your note, I haven't got time to take you to this, but when you're, you know, because the judges are all going to look at all this again once they come to write the reserved judgment. So you can kind of keep what the things that you need to actually look at, given that everyone is struggling with electronic bundles, to the minimum. I think that's the help.
Well, it's possible to say what is good advocacy by thinking about what's bad advocacy. And one example of bad advocacy that can come from quite senior people is making points that are not designed to be right, that are not designed to persuade, but are designed to please the client, professional client or lay client. He's a real fighter. There are people who make whole careers from being real fighters, and we know who they are. It may surprise you how much we gossip about you. If I've listened to you taking a series of bum points because it'll please your professional client, I will remember that. So being a real fighter is not a good way of being an effective advocate, even if it gets you the next case, because in the end, you will be pigeonholed as somebody who is a go-to advocate for difficult cases by difficult solicitors, where expectations will be too high and where our hearts sink when you walk into the courtroom. So only take the points that you think are correct. You see it in skeleton arguments in civil quite a lot. And I've tackled one or two leading counsel about this, and they say, well, Stephen, you don't always understand. I'm not the only person drafting my skeleton argument. It has to go in draft to my solicitors, and then they send it to the corporate lawyers, and they all want all these points put in. And the result is a mishmash of every point, either that somebody likes the look of, or that protects the professional reputation of the in-house lawyer in the corporation concerned, because they thought that was a good argument. And if it is abandoned, it makes them look bad. That is not the right way to get to the right result as an advocate. It's the reverse of it. And I think we have a little bit more time, but not too much. Has the new technology or using third-party software caused delays to pending cases? I think the answer is no. It has unstopped the delay to a degree, but it is slower, more difficult to organize, and so it has mitigated the delay causing from COVID. But boy, is that delay still building up. And I think particularly in criminal, where the system was hugely underfunded before and is even worse now, And there are the intrinsic difficulties of jury trial. So there's an enormous backlog building up in jury trials, which is why the Lord Chief has suggested the idea that, at least for cases which are triable either way, not so serious, one might explore as an emergency dealing with it with magistrates and a judge. Vivian, I don't know whether you want to come back on that.
I think, it's got very echoey, but that I understand that there's not a huge backlog building up in the Court of Appeal Civil Division. There were quite a few cases that were adjourned very early on, but most of those are now coming back in the list. We did wonder, and there was some debate about whether we would all be sitting during the vacation, but my understanding is that that prospect has receded, and that we have been getting through the work. And my understanding is in the business and property courts in the Rolls building that they have managed to get through about 85% of the business that they were planning. And I think it's also important, and I know that the Lord Chancellor appreciates this, that the courts here compare quite favourably with a lot of other jurisdictions which just did not move to remote hearings, which are building up a backlog. But we did move surprisingly seamlessly in the civil side, at least, in the areas where there are professional clients, to remote hearings, and it has gone quite well.
We've got one question we haven't looked at from Lee Minong. Would you briefly describe an instance of virtual advocacy you were impressed by? Well, I can tell you that for the last 3 days, until about an hour ago, sitting here, we've had a civil appeal to do with a case called Robertson Johnston, how one addresses the difficulty of properly compensating but not overcompensating a personal injury claimant who needs a much more expensive property. Needn't go farther into the detail of that, but very unusually for a civil appeal, firstly, we had 7 expert witnesses giving fresh evidence in the appeal. Secondly, it took 3 days. Thirdly, there were not only appellant and respondent silks, but an intervener in the form of the Personal Injury Bar Association with the silk. And subject to the 1 or 2 technical glitches that were nobody's fault, they got through the most amazingly complex and voluminous case in 3 hard working days. And they were terrific. So it can happen. And they did it by preparation, by removing the unnecessary issues, agreeing that certain possible solutions weren't possible, focusing on what really was, might be in solutions to the legal and business problems, if you like, that arose. They were terrific. We were very grateful for that.
Yes, I think that, I mean, it's always a pleasure for the bench when the barristers are cooperating, however hard fought the litigation is. If one has a feeling that the barristers are able to get over that and assist each other so that everything goes smoothly, then that's always impressive. And I think in the virtual thing where everyone's a little nervous about what's going to happen, it's even more important. And the things I've been impressed with is when barristers have not sort of taken advantage of the discomfiture of someone who's struggling with some aspect of the technology of the remoteness, but has come to their aid to get over the hurdle so that the hearing can continue. And I think that's very important.
Well, I think we've gone a little bit past our 6 o'clock witching hour. I hope you have all found this useful and reasonably interesting. Best of luck with your future participation in virtual hearings or ordinary hearings when, let us hope, someday we get back to seeing you face to face in the courtroom. Thank you very much. Thanks to my co-panelists. I hope that they enjoyed themselves. Good evening to you all.